years, in person and self-represented in a paternity case he filed in 2025 DM 337. Ms. Jackson appears. Ms. Jackson, you came to the courthouse?
Oh, yes, Miss Jackson is nasty.
Yes, I did.
Okay. Where do you live?
Andover.
Okay. Thank you for appearing. And we have DCF represented by Ms. Hawks. All right.
Ma'am, are you a whore?
There is a corresponding child support case in 25 DM 186. It's this court's opinion that the motion to set aside the VAP could have been filed there, or in a paternity case. So Mr. McMillan brought his own paternity case where he's disavowing or trying to rescind the VAP. It isn't to establish that he's the father, but rather that he's not the father.
Correct.
He is on the voluntary acknowledgement for paternity. And in your petition, you indicate, or in your motion, I should say, to set aside that you filed. You indicate that the acknowledgement of paternity was within 1 year of your request to set it aside. But I don't have a copy of it. DCF has access to it. You have access to it. DCF has access to it by statute, but I don't have it. And I thought I had requested that you send us a copy of that so that I could, I assume it's right around the time that the child was born, but so that I could confirm the date that you executed that.
Executed are you talking about the final motion or my forms that I sent in earlier? Because I was told in a letter that I got from your assistant that the forms would be that were received would be good enough to go along and start the court filing procedure, and I just needed to turn in a final motion to have it on paper. I was emailed by your assistant, Amy, a while ago. I can check the dates that you guys did get the final motion. And so so what paperwork are you referring to that you do not have?
The actual acknowledgement that you signed at the hospital as.
Okay. Yes, no, because there was none. I specifically asked the delivery nurse for a paternity acknowledgement form and a DNA test prior to the child even being born in the hospital room. I was then told by the delivery nurse that they do not do neither of those two legal documents in the hospital, and this is at Wesley Medical. The only thing I did sign was the birth certificate, which under my what I've been told is not a sign of paternity establishment.
Your Honor, if I may,
Yes.
I have a copy of the signed voluntary acknowledgement of paternity. I apologize, I had not provided it because it was my understanding today was a pretrial conference, but I'm redacting the confidential information right now, and I'd be happy to email that over to Ms. Boakman if you'd like to see a copy of it today.
Yes.
I will get that emailed in just a moment, Your Honor.
Is that Amy? Can that have can that be emailed to me also?
I can email it to both parties, Your Honor.
Yes.
Okay, thank you. But yeah, what I said in the hospital, I did ask for a paternity acknowledgement form and was told that was not what Wesley Medical provided. So I'm not entirely certain what piece of paper she's referring to.
Well, you being on the birth certificate does create a presumption under the law. But when you actually sign an acknowledgement, then that has greater force and weight unless it's challenged within a year. I mean, you're really excluded from being able to challenge it at all if it's been after a year.
Well, I sent in my I don't have my paperwork with me right now. I'm at work, but I sent in a bunch of forms requesting paternity testing and denouncing paternity.
Yeah, I have that. I have that in the court file. I just don't have a copy of the VAP, which is the voluntary acknowledgement of paternity.
Oh, okay. Okay. I don't either.
He's a big dummy, but I feel sorry for him. I really doubt he's the father.
Can you send that, Amy, to my Gmail, please?
Your Honor, I just hit send on the email to Ms. Boakman, and then I will send it an email now to Mr. McMillan and Ms. Jackson.
Okay. Mr. McMillan, where do you work?
I work for my brother. It's called the Sign House in Salina, Kansas. My brother is Robert Harper. Yeah, I'm sorry if it's a little loud. I just stepped in the break room. I'm on
No,
my
that's
break.
fine. No, you're fine.
Mr. McMillan, can you remove your hats, please?
Yeah, I'm sorry.
Okay, so Mr. McMillan, have you gotten the VAP?
I will check.
I'm about to hit send on his email, Your Honor. I was sending them separately.
Okay.
Behavior in this case is disgusting.
it looks
All right,
like it was
grab a white claw,
executed
settle in today,
9/10
we got a
of
true legal
2024.
So while we were still in the same in Wesley. So yeah, I specifically asked, I have to look at this because I did ask the delivery nurse about the paternity acknowledgement form.
Well, I mean, you executed one. So unless you're gonna, establish there's a forgery, you have in fact executed one. And so this petition was filed on the 8th of September, not the motion, but the petition.
And I was told in a letter that the petition would be considered the motion until I get it there, and that was well past.
Well, they
date.
might dispute that, but I mean, I kind of did treat your petition as notice that you were disputing. I don't see a filing date of your motion, unfortunately.
Your Honor, I
Or-
believe it was filed on November 6th. There's a fax notice up at the top. I believe that's what they're using as. the
Yeah,
filing date.
I can't read mine, so,
It's November 6th.
okay. So what is the state's position on the VAP and by virtue of filing the petition on September 8th with regard to his ability to contest the VAP within 1 year?
Your Honor, I mean, I believe I knew what his intentions were on the September 8th filing, that he was intending to set aside the voluntary acknowledgement of paternity. So I'm not necessarily asking that he be barred from making any argument because he titled the document a petition versus a petition for concerning paternity opposed to a petition to revoke the voluntary acknowledgement of paternity. However, I mean, I think he still has the burden and it's on him to prove that.
Okay, she's reasonable, but still, get an attorney, my man. Get an attorney. You don't know what you're doing.
He signed that voluntary acknowledgement of paternity based on fraud, duress, or material mistake of fact.
So I did look at the paperwork. I really don't remember that. It was after, but I will say it was after 24 hours of her in delivery, and then she went into a C-section. At the time of signing, I hadn't slept in 36, maybe 48 hours.
I mean, that you're presumed to know what you sign, so.
And I did ask the delivery nurse about a paternity acknowledgement form, and they said they did not do that. So
Well, they obviously do. The social worker must have came in. Somebody brought in this form because you executed it. So we need to set this for trial. I have not looked at whether the burden of proof is clear and convincing or a preponderance. Does it indicate in the statute?
Your Honor, the language says the person requesting revocation must show and shall have the burden of proving that the acknowledgement of paternity was based upon fraud, duress, or material mistake of fact, unless the action to revoke the acknowledgement of paternity is filed before the earlier of 60 days, which obviously was not filed 60 days after he signed. I don't see if it's preponderance of evidence or clear and convincing. I can do more research, Your Honor, to determine that.
Okay, because the burden of proof matters. I mean, he has the burden of proof. The standard of proof is what we need to clearly establish.
So
Okay.
you need proof on why I think this is not my child.
No,
No.
look at your motion you filed. By statute, read the statute.
I currently forgot my paperwork at the house. I'm
Okay, well, we're not doing it today anyway. I'm gonna
Okay,
schedule it for an in-person evidentiary hearing. But, you have to prove when it's greater than 60, but as long as it's under a year, which you've met I'm finding that you've met the under a year. Not only did you orally, contest paternity in your 25 DM 186, but you subsequently filed a petition in 25 DM 337 and then followed up with a formal motion. So I'm not going to find that you're time barred for the 1 year to be able to challenge it. So you have succeeded there, but then what you have to do is you have to prove that you signed that document under mistake of fact, without full knowledge of the relevant circumstances, and so that it constitutes some form of fraud, misrepresentation, etc. Okay?
okay.
So-
Okay. I'm sorry.
That is what you have to prove. I would strongly recommend, if you truly do not believe that
This is absolutely nuts. I know it's been this way forever, but if the DNA comes back, it's not yours. You should get out, and that's that. I don't care. I don't care if you were married. I don't care if it's 15 years later. I don't care. If it's not yours, you shouldn't have to deal with it.
you are the father, then I would strongly suggest that you try to obtain an attorney, because it's going to be cheaper to pay an attorney now to help you proceed with this case than 18 years of child support. So you make the decision, but you're going to be acting as your own attorney. You definitely have the burden of proof. And you have to prove fraud, duress, or mistake of fact. Or that document is a full-fledged forged document.
I
That's
mean,
the way the law works.
Okay.
The law wants to establish fathers, and the law doesn't freely allow, once a person has legally acknowledged paternity, to just rescind that. So that's just the way the law is stated and the way it works. And so I'm going to give you enough time to prepare your case and subpoena your witnesses and do whatever you think you can do, your own testimony, any exhibits you have to show
Yes.
fraud, duress, or mistake of fact. Okay?
yes, so I do have a it's all electronical evidence that would back my theory on why this is not my kid. The other person texting the defendant or
Okay.
other.
So you're not proving that it's not your kid.
Did you just say it was electronical? Sweet Jesus.
What you have to prove is the document that you acknowledge that it was your child back on September 10th of 2024 was signed under a mistake of fact, fraud, or duress, or some form of misrepresentation.
I think he can show that, or at least I think an attorney doing it can show that. And I think he can turn this boat around if he's not the father, but not if he's doing it himself.
Okay, that's what you're proving. Then if the acknowledgement gets set aside, Then the court can decide if it's in the best interest to order genetic testing per your request.
Okay.
Which the child's young enough, quite honestly, I probably in holding the Ross hearing would take into account those factors. So we may get there, but you legally have to present sufficient evidence to set aside this document that you apparently haven't fully looked at.
I just looked at it. My initials. I mean, it's
Okay.
so yeah. They're
All right, I'm gonna set this for an evidentiary hearing. Again, I would strongly,
Can I get a court appointed lawyer?
no,
approved by court? No.
no, not in a domestic case, no. Cause you're not gonna go to jail over anything, so no, you're not entitled to the appointment of counsel. Ms. Hawks, do you think that we ought to have a specific pretrial order? Or are you satisfied with just scheduling this for a trial?
Your Honor, I'm fine with scheduling it for a trial. I think there's pretty much one very specific issue. I don't know that a pretrial order would be necessary.
Okay, okay. So if you're going to subpoena witnesses and or talk to an attorney, today is the 24th, you need at least 2 to 3 weeks to subpoena witnesses. I actually think either the afternoon of January 8th or the afternoon of Friday, January the 9th would give you enough time.
Yeah, it's the time's not the problem. It's more like the money. I've talked to many lawyers. A retainer fee is $4,000, and I don't have that money. I don't
Keep
know.
calling, keep calling.
I mean, that
Yeah.
was the lowest retainer, and I have called 3 counties worth of attorneys: Butler County, Sedgwick County, and Saline County. I have called every lawyer that will pop up online. The lowest retainer fee is $4,000. I don't have that.
Okay. Well, I don't know what to tell you. Contact legal aid then.
If you don't have that, then you don't have money for 18 years of child support.
And see if there's somebody from legal aid that would represent you, or if they would give you some references that people that do reduce fees or don't require a big retainer. So contact legal aid, see if there's some association that provides some advocacy group. I think you ought to try more attorneys. They're going to need, though, that VAP and any evidence that you have. But most of them will at least consult with you for an hourly rate to consult with you. So I'm going to go, and they can continue the trial if they need more time or you need more time to pay or whatever the case may be. But I'm going to get this scheduled for trial. That's all I can do, sir.
All right.
Judge, I will say on January 8th, that is where we have the probate trial with Miss Henry, Miss Sir, and Mr. Elliott scheduled from 9 to 5.
Okay, it's not in my book.
It's not.
All right, so, well, that's not gonna work, and that's backed into backed into a Greenwood week. That probably wasn't
Sure.
very smart.
Correct.
All right, I don't know that I want to turn around and have another trial January 9th, but this case has to be heard.
And the 9th, you've got a 9 and 10 pre-trials on civil cases, and then we just have a name change at 1 o'clock that day, but I could move it.
Okay, that's not on my calendar either.
Except for, yeah.
No, I don't want to move. move that. Well, we could do the morning of January 23rd. And that means we'll just be limited on that domestic day. You're just gonna have to find some place else to put some of the domestic, Amy.
Okay, the only hearing that we've got scheduled that day outside of first appearances is at 11 o'clock, and it's a case that I moved due to the Coley sentencing. And I believe
I don't have that on my calendar either. Okay, so Ms. Hawks, does Friday, January the 23rd, of course, that's child support enforcement on Fridays, isn't it?
Your Honor, Judge Murphin is the first and third, so I believe that's the fourth Friday, so I should be available.
Okay, do you want to do 9 to 11 or do you want to do 3 to 5?
I would prefer 9 to 11, Your Honor.
Okay. All right, so sir, you have 2 months to get your case put together. Go online, go to YouTube. If you've got to represent yourself, figure out how to do it, subpoena witnesses, look at the statute, read whatever you can come up with. That I cannot give you legal advice. But that gives you 2 months to either secure counsel and have them ready to go, or
If you think electronical is a word, you can't represent yourself. That's it. There's no two ways about it.
entered in your case as your attorney or ready to try the case, okay?
All right.
So that is Friday, January 23rd. I would suggest that you print that document out and that you have it available. Ms. Hawks, do you believe that that should be filed under seal in the court file, or just
Your
made
Honor-
part of the record in the trial?
Your Honor, I did redact any of the confidential information before I emailed it to the court and parties. I'm always partial to filing anything like that under seal, but if somebody objects to that, that's fine as well. And if Mr. McMillan or Ms. Jackson either obtain counsel, I would obviously be happy to send them a copy as well.
Yes, Shelley, that's wrong.
All right, sounds good. I think I'll just make it part of the trial record at this point. It could have been probably attached as an exhibit to the motion, but I don't think he's gonna figure out how to go back and do all of that. So, I think that as long as everyone has it and understands that that's gonna be an exhibit in the trial, then and part of the record, I think we'll be okay with that.
Yes, Your Honor, and I had intended to admit it as an exhibit at final hearing, so.
Sure. I mean, I think it's gotta be. All right. 10 days prior to the trial date, I want you to provide a list of witnesses and a list of exhibits to opposing counsel and to the court. Okay, so that would put,
And how would one go about doing that? Do I send it? It's electronic. Do I send it through email? Would I send it to your assistant?
you can print it out and mail it to the clerk of the district court, or we get notice of everything that you file.
And good job with electronic. I think there's hope for you.
Yes, so I have an audio recording of the mother admitting to selling herself for illegal drugs on conception date. It's an audio recording, ma'am. And the drug dealer texts her and asked if it was her child. And her response was, I don't know. I have a screenshot of it, Your Honor. An audio recording.
Okay, well, you're going to have to,
Ma'am, are you a whore?
authenticate it by calling her as a witness, seeing if it's, I mean, you're gonna have to research how you're going to introduce that into evidence. And you've got to provide it to the other side. So Ms. Hawks is prepared to know what the evidence is going to be, as well as Ms. Jackson has a right to know what the things are that you are going to present. Okay? And then you've got to get it admitted, which is why I'm telling you that it is a very good idea for you to secure an attorney, even if you
Yes.
have to get a loan from somebody, because you're going to be paying a lot of child support for the next 18 years. I think it's more important for a child to know who their father is and for a child to be involved in their life. But I'm just trying to impress upon you that you get one shot at this, and it's not that easy to act as your own attorney. Even if you're an attorney, it's not that easy to act as your own attorney. So witness list and exhibits need to be exchanged by January 14th. All right, if there's nothing further, we are adjourned.
Mayor Caruso. Call.
Assistant Public Defender Davy Lieb on behalf of Ms. Perusa.
State your name.
Mia Caruso, sir.
The first case I called up when I came to the second half of the document.
My apologies, Your Honor.
She's darn near last. No, we all understand it's your fault. All right. I am.
As well as in divisive rights, Your Honor.
The plea form indicates that the defendant will be pleading guilty to an added count to a false report of a misdemeanor to 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. And it's also agreed that the prosecutor will be recommending sentencing under the Homes Useful Training Act.
Yes, Your Honor.
That's the court's full understanding of the agreement.
That's mine as well.
Yes, that's a complete recitation.
May I have her sworn, please?
Right hand. You solemnly swear and affirm to testify the truth, the whole truth, and nothing but the truth.
Yes,
State your name, please.
Mia Caruso.
Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of false report of a misdemeanor. That itself is a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. You understand that?
Yes, Your Honor.
You also understand that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
And you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to date?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes.
of your own free will
Yes.
and because you believe that you are indeed guilty of this offense?
Yes.
February 2nd, 2025, at the location of 2680 International Drive, apartment 801A, Ypsilanti Township, Washtenaw County, State of Michigan. What'd you do that makes you think that you're guilty?
I had falsified some of the details in the reporting saying that it was stolen while it was getting warmed up for a gas station run.
Say again?
Your Honor, may I have blood here?
I had
I want to-
falsified some of the details stating that the car was stolen while being warmed up for the gas station, and that's not like how it was stolen.
So it was your car.
A company's car,
Oh,
my possession.
it was a company car.
Correct.
Where you worked or formerly worked?
I was formerly working for that company.
Okay, and you had one of their cars.
Yeah.
And so where was the car when you made this report?
When the report was like initially made, I believe it was already crashed.
Okay, so let me get this right, young lady. You had a car, it was a company car, you crashed it.
Someone that I know that like technically they stole it, they crashed it, and I had reported that it was stolen while it was like waiting to be warmed up at the gas station, but in fact it was already like
Hey, hold on. So somebody you knew stole the vehicle, or at least drove it away without your permission.
correct.
They crashed it,
Correct.
but not so bad that it was undrivable.
It was.
You-
It was flipped upside down.
It what?
It was flipped upside down. It ended up like getting flipped in the crash.
Okay, so then at some point, you called the police because of that?
Yeah. Like they had told me that like, hey, I accidentally crashed your vehicle. Can we like get this figured out? And I was like, okay. Let me come up there,
So, hold
figure out
on,
what's going on.
hold on. The police arrived at the crash scene, right? Or no?
I
Your Honor,
believe,
if I may, she was not present at the crash scene.
yeah, I wasn't at the crash.
Okay, so they called you or somehow got through to you and you needed to call the police.
When after like I got a call from like my friend saying that they crashed my vehicle, I came up there and I had reported that like the vehicle had been stolen. It had been stolen while it was being warmed up for the gas station. When in fact,
Okay, now the gas station fault. I couldn't
Yeah.
figure out after the
Like,
crash how it got to the gas station.
you're like,
So,
Yeah.
you told the police that the vehicle got stolen when you were warming it up at the gas station.
correct.
That was incorrect and false, right?
Yeah.
And the very fact that, well, you knew how it was stolen, but you didn't disclose that to the police.
After I got brought in for an interview, is when I disclosed like the whole
But your
story.
initial report,
But yeah,
not
correct.
that, correct? Okay. And in doing so, you were in telling them about the warming up of the car and then whatever, then you were intentionally misleading the police and that report was a false one. Is that correct?
Correct.
If I accept your plea, I need you to understand that if you commit misconduct between the time that I accept your plea and the time of sentencing, you commit misconduct as defined in the Michigan court rules, that any sentence evaluation or recommendation the court would no longer be bound by, and you would not be entitled to withdraw your plea. You understand that?
Correct.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None known to the defense, Your Honor.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's?
Yes, Your Honor.
Satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
January 15th at 10 a.m.
January 15th, 2026, 10 a.m. That is before Judge Washington. For a bond. Why?
Like, why did I say it?
Why all of this?
I didn't know what to do in this situation, to be honest. Like, it was like from 3 to like 6 a.m. I was just like tired. Didn't know what was going on. First ever like crazy thing.
How old are you?
20.
Is your dad with you?
Yes, sir.
What did he say about all this?
It was a dumb and crazy thing I got myself into.
Is that what, that's what your dad said? He just looked at you and said it's a dumb and crazy thing?
He was kind of like, what the heck were you thinking? Kind of like type of deal.
And when your dad asked you that, what were you thinking?
Same thing. I didn't know what to do in that state, in that situation. Yeah,
And he raised you better than that.
did. He did. Sir.
Are you in school?
Not anymore, sir. I used to be going to college for business.
And what happened?
With school,
Sure, let's start there.
I wanted to start focus on making money and saving up for stuff.
So when you said you were going to do that, just ask a question. What did dad say?
Wasn't the biggest like supporter of me.
Hold on a
Got
second
out
before
college.
you start that statement. What did your dad tell you when you said, I'm not going to school, I'm going to go out and just make money?
He is normally really supportive. He has like his own like little opinions. He kind of gave me like a look more of like speaking anything.
Okay, so what was dad telling you?
He was telling me kind of that I was making a bad decision
Yeah. And why do you think he was telling you that?
because I probably should have focused more on school. Because school can higher my chances of a lot.
I mean, although dad didn't say it, you know he wasn't happy when you made that decision, right?
Yeah.
So why were you trying to skirt around it? I'm a dad myself. I know he was not happy.
Yeah. I just thought like making money was like I don't know, a tried good decision. And I wasn't really like 100% on going for business. I was still kind of like mixed up and I didn't want to like get myself wrapped up in like tuition debt, and all that. With
So
like,
let's see, you went to school, the whole world's in front of you. You can decide from anything. It's just a buffet of things, but gee, you couldn't decide. So I just didn't want to do that. And I wanted to go out and try to make money.
yeah, that was kind of like my
So how's that working out for you?
not the best. I have been thinking about like getting back into college
Really?
or trade school. But it's just the step I gotta take to get back into.
What did your dad tell you to do?
What did he specifically tell me to do? He'd encourage.
What would, no, why, I don't know why you're stuttering whenever I ask you that. You know darn well what the man would tell you. What would he tell you to do?
He'd tell me.
Because if you don't want to tell me, I'll bring him up here and have him tell me.
He would tell me to go to college and get my.
Would he?
Yeah.
So let's see. You're just too grown to do that because you're all 20 now.
I wouldn't say I'm too grown. I need to figure stuff out a lot.
What do you need to figure out? You're 20. You figure nothing out. You know nothing.
Yeah. Correct.
I know. I've had one of you. So when are we going back to school?
I was trying to go for like psychology. And so when I just don't want to be in debt my whole life. That's my
This is gonna
biggest,
be
like,
one of the long daughter stories. Go ahead. What?
I just don't want to be in debt. Like, that's my biggest, like, thought process is I don't want to be in debt for a while or for like, not ever, but like, if I would rather have the choice to be in debt or not take debt, I'd rather not.
It's America.
Yeah.
I don't know
Yeah.
why. When are you going back to school?
Hopefully by next
No. We're not doing hopefully.
February of next year,
Perhaps when you leave court today,
Or-
it might be
or
a
no,
good
leave
time
court
for you to
today.
look into that.
even more.
Can I just ask you this? Why wouldn't you just do what your dad may want you to do? Is there a reason?
Not necessarily. It's just I'm bad at starting stuff and sticking with it.
No, your dad came down and sat with you at the last year.
Yes. Each one of them.
Oh, I know. I was watching. And he just sat there very patiently while you were going to come up here before the court. I'm sure he had other things that he could do.
Almost definitely.
But I watched that man and he never left his daughter's side. Right?
Correct.
So why can't you do something that would probably mean the world to that man?
Yeah. You are right.
What?
I said you are right. I do.
I know I'm right.
Right.
That's right. But why can't you do that for him?
I could. I just gotta put forth the effort.
I do like, I know I'm right. I'm not looking for affirmation here. What? Just answer my question.
Tell you what, Miss Wiley, can you call Judge Washington before I talk to her? I'd tell her I'm keeping this case. You are going to go to school.
Thank you, sir.
So her sentencing date will change. What is it? We're going to do it December 22nd, 2025, 9 a.m. That's before me. Everything's going to need to be paid at 14B, but so now that this case is mine, when are we going to school?
I'll figure it out as soon as I get out of here, sir.
I heard your attorney tell you that. What's wrong? Why are you crying?
That's just like a great opportunity.
What is?
Being able to like not only like get it in front of you, but like be able to go back to school. Like actually, it's just been hard to get my life together, to be honest.
That was?
It's been a bit hard to get like my focus straight, my life together for like a minute.
It's not going to be that hard.
Yeah. Thank you.
The thing that you got to do, you just got to put. Yeah. You just got to do it. You think everything for your dad throughout his life was easy?
No, it's definitely not.
So there came times where he just had to make that first step and then go to that next step. Where were you enrolled in school?
Monroe Community.
Monroe. So their classes, like every other community college, will start back up in January.
This should be the first step.
Yeah. And so you can go down there. You know how to fill out FAFSA?
Yeah.
You know about all of that.
A little bit about it, yeah.
Well, you better find out a whole lot about it. And I want you in classes by January. And when I say that, I don't want any cream puff classes. You come in here with underwater basket weaving or something like that, and I got someplace you can sit until you rethink that decision.
Understood.
Understood?
Understood, sir.
Young lady, if there was anything in the world you could be and would want to be, what would it be? Just
You're gonna think I'm crazy for saying.
No, I don't think anybody's crazy. Well, you're an attorney. I don't think anybody's crazy.
Judge.
But just a little. What would you want to be?
One of my dreams since I was a little girl was to get into like modeling and acting. Just because it's something my brother used to do when he was younger, and
Oh,
just
sweet
thought
Jesus.
that would be
Here we
just like
go.
a great career path for me.
Okay. And if you want, no, that's not crazy. But if you wanted to follow that dream, why don't you? Because here's the funny thing. You can have that dream that's what you want to do. The great thing about life and the great thing about education is that as you're going on that journey, all of a sudden you see something else. And now's the time in life for you to be able to sort of grab onto something else and just look at it. Because there's a whole lot out there that you have no idea about.
So you're saying OnlyFans?
Nothing. I mean, you just don't know. It's a whole world open up. So you're going to be on a journey with me, and you're going to figure that out.
Absolutely.
Got it?
Yes, sir.
Dad, you want her back, or you want me to change her bond? You want? See, he didn't even have to take you back. All he had to do was say, "Judge, take her." You'd be gone. I wouldn't even ask any questions. Bond will continue, young lady. Have a wonderful Thanksgiving.
Thank you for Your Honor.
All right. And you will get in touch with my probation department down here. They're down the hall on the left. And Ms. Polero will explain to you how I am about school.
Okay. And then any future dates that I need
The 22nd, she said.
22nd. So I'll see you before Christmas. And we'll decide if there's going to be a Christmas. Because if Dad comes in and say he's disappointed, you're going. All right.
Yes, sir.
You take care.
Thank you, Your Honor.
Thank you, Your Honor.
Dad, take care of yourself.
In the matter of the state of Michigan versus Jeffrey Biggs Jr., 232366.
Good
Counsel?
afternoon. Christopher Shepke, appearing on behalf of my client. It's time we consent to the matter being heard via Zoom.
Okay, and Mr. Biggs, your name for the record, please.
Jeffrey Alvin Biggs Jr.
Okay, well, so Mr. Biggs is in custody based on a warrant this court issued October 3rd of 2024. He'd previously been arraigned in this matter, and so the court is indicating the warrant would be recalled. Set this for probable cause conference on December 4th.
9:45.
9:45 a.m. And as to bond counsel.
Your Honor, Esteban, my client is currently 38, no probation. He indicates he's not on probation parole. He doesn't have any other pending cases. He lives with a friend in a local city. He does receive SSD for mental illness. He's had that since 2011. Indicates that he graduated high school in 2005. I know that financially he won't be able to make any monetary amount as it applies to postings. So we'd ask if a personal bond were not to be granted, we'd ask for a 10% or cash surety provision. Thank you, Judge.
Okay, so there's a few things going on here for Mr. Biggs. Well, Mr. Biggs, let's see. So I'm just going to go through the procedural history here for a moment because it's important as this court determines what the bond is going to be in this matter. This matter is alleged to have occurred November of 23. The defendant was set to be here January 25th of 24. He failed to appear for his arraignment. Warrant was issued on January 31st. Sir, you'll have an opportunity in a moment. Then on June 6th of 24, this matter was supposed to be, it was scheduled for July 11th at 9:15 a.m. And then there was a writ that was sent because Mr. Biggs was in the Macomb County Jail. So on July 11th of 2024, the arraignment was held, scheduled this matter for probable cause conference July 18th. The court ordered a $10,000 personal bond at that point, as defendant was serving a sentencing with an expected release date after the probable cause conference. On July 18th, the Macomb County Jail did not log in with the defendant for the probable cause conference, so the court adjourned it to August 1st. August 1st apparently was not a good date for the Macomb County Jail, so we adjourned it to August 8th. August 8th, Mr. Biggs was present. However, his attorney was late. Then, after Mr. Biggs was on Zoom for a while, the Macomb County Jail logged him off because they were tired of waiting for his attorney. So then the court waived the appearance of Mr. Biggs and then set it for an exam on September 5th of 24. On September 5th of 24, the preliminary exam was not held because Macomb County Jail would not release Mr. Biggs due to an arraignment in 41B District Court. Adjourned the exam to October 3rd of 2024. October 3rd of 2024, defendant failed to appear and was no longer Macomb County Jail. Immediate warrant to issue. That was the last we've heard from Mr. Biggs. Well, we didn't even hear from him that day either. And so what is it you want the court to know, sir?
I will tell you, I was in jail for the whole time, pretty much.
Well, when were you released, sir, from jail?
Yesterday.
Yesterday.
Yeah.
And which case was that on? Because there seems to be a lot of them for you.
There's quite a few.
Right. So which case was this one on that you just were released from jail yesterday?
Disorderly person out of out of E-course.
A what?
Disorderly person out of E-course.
Okay. Sir, let's just clarify something here. All right. Sometimes I feel like I may look young, sometimes I don't. All right. But I'm not stupid. You were released from custody from Macomb County Jail. When were you released from custody from Macomb County Jail? Because that was not yesterday.
No. That was a different case. I was in I think October or November of 2024.
Correct. So don't try telling this court that you didn't come to court because you've been in custody pretty much the whole time, because that's not accurate.
Okay, never mind. That's not what I meant to say, but okay, man. You don't have to yell at me. I'm listening to you. Listen to your regular voice. You don't have to yell. It's okay, man.
Excuse me. You are not going to speak to me that way, sir. What I don't appreciate is for you being dishonest and misleading the court.
I didn't mislead the court.
You sure did.
I've been in jail since.
Stop. You said I've been in jail the whole time, pretty much. That is what you said.
I meant to say I've been in and out of jail. I'm sorry.
What an a-hole.
In and out of jail the whole time.
Then, sir.
Like this is a felony. So it should take precedent over any other case. But it doesn't for some reason. I don't understand why the court hasn't already brought me here. I've been arrested 4 times since I've been out. And you haven't brought me here for what reason? Because you don't have a case.
Stop right now. First of all, I don't get to bring you here. That's on the police department. So I don't know what communication occurs between the police departments, sir, and whether or not there's a case or not. That's for the attorneys to determine if they want to present the case to the court. Once the case is presented to the court by way of preliminary examination, then the court will determine whether or not there's evidence or there's a case. So the court will also note that there is a preliminary exam scheduled. However, because you are already in the Macomb County Jail then their local 41B was conducting an arraignment for you, which apparently took precedent over this court's case. And perhaps that is from the matter from Macomb County Sheriff, December 31st of 2023, felony assault with a dangerous weapon, 2 charges of that. So I can see why they kept you there and didn't log you back in. Nevertheless, sir, you're very much aware that this matter is pending. Whether you've been arrested 10 times or no times, you know this matter is pending, and you did not do one thing to address this matter at all. Did you email into the court, sir?
I don't have an email, man.
Did you come into the court?
I came to one that dog pound and picked up my dog. I came to your police station to pick up my dog. I came to your police station and picked up my dog when it was stolen from me.
Hold on, let me clarify, sir. The court does not have a police department. The city of Wyandotte has a police department, not the court. So it's not my police department. And what about your matter out of St. Clair Shores, sir?
That's been resolved.
Okay.
They gave me a county year for it. I did a county year for it. For cyberbullying, which is a whole strike on the First Amendment. That's neither here nor there.
For what?
That's a whole thing against the First Amendment, but that's either here nor there. I already done that. I did the jail time for it. It's over with.
Okay. So let's see. You have a matter from June of 2025 from eCourse, misdemeanor assault. And then you have another one from October 31st of 25 for solicit misdemeanor damage of property and solicit felony burglary. So which matter were you in custody for until yesterday?
What was that burglary anyway? I never burglaried anyway. What are you talking about?
Those were your charges.
For what?
Oh, and then also public peace. So is that what you were just released on yesterday?
I already did the time for those already.
Sir?
What do you think? I just came from Wayne County Jail for doing the time for those.
Excuse me, sir.
Yes.
My question is, which one of those were you just released from custody from yesterday?
All 3.
Oh, okay. All 3. And so, sir, who do you live with in Newport?
Katrina, my friend Katrina.
And how long have you lived there, sir?
A long time. Not sure.
Okay. And you don't work?
No.
And so, sir, while you were in custody, were your Social Security disability benefits terminated?
Yes, ma'am.
And so have you started to receive those again?
No, ma'am. No.
And so then how are you supporting yourself then, sir?
What do you mean, ma'am? I've been in jail. I don't have to support myself. I don't have to support myself while I'm in jail. I'm in jail.
Well, you've been in and out of jail, you stated.
When I got out of prison, they gave him back to me. When I went to St. Clair Shores Jail for cyberbullying, which is a bullshit cause. Okay.
Excuse me, sir. You're on the record in court, so you need to really check your language.
Okay. Well, it's BS. It's a BS charge.
Okay.
I can say somebody is fat and smells like old hot dog water. That's not a crime. It's not a crime to say that.
To say what?
Never mind. I'm on the record. I'm going to keep it to the simple. When I got to St. Clair Shores Jail, they gave me my check back. After 7 months, I had back pay. With back pay, I bought a car. With the car, I was going to and from Untouchable Tire. Okay, and then I got arrested again for something that happened in 2023 before this case even happened. Okay, I went to Wayne County Jail. They shut off my check when I pled guilty. They shut off your check. Okay, when you plead guilty to a crime, they shut off your check. They shut off my check. So I currently do not have a check. Okay, am I making this any clearer to you? Because this is an LD courtroom. Apparently you're LD. Apparently. So can I please go back to my cell now? Because you
I'm
just
sorry.
Say to me. Did you just say? Can I please go back to the cell? Can I go back to the cell?
What is an LD courtroom, sir?
Learning disabled.
Learning disabled.
Yes, ma'am.
You think this court is a learning disabled court?
Give me no bond or give me whatever $10,000 bond, $100,000 bond. Doesn't matter. Okay.
I did not see any of this coming. Holy Toledo. This guy is something.
Just give me the bond and let's get on with this. You're dragging this on for no reason. You're gonna give me a bond. I'm not gonna pay.
Excuse me. Stop talking. Stop talking right now. I'm going to show you how much not learning disabled this court is, sir. Because you are the one that's been dragging this case on for your failure to appear in court. So this is what this court's going to do. This court's going to issue a $25,000 10% bond. In the event bond is posted, GPS tethered through the Wayne County Jail, not to possess or consume any alcohol or drugs unless prescribed. And sir, your lack of excuse me, I said stop talking, please. Your lack of respect for the court, sir, is not going to be tolerated. We'll see you back December 4th.
Thank you, Judge.
Have a good day.
Well, that was just pure fun. It really was. She handled it fine. She did get flustered though.
SEAC. Wait a minute. Terry Ann. Oh, yeah. Where's Mr. Coleman? Is Mr. Coleman here?
I haven't spoken to him today.
He's actually on the phone saying that he's been in the waiting room, but I don't see him.
Mr. Johnson.
He showed up late last time, too, by quite a while, didn't
He actually showed up a couple hours early, and I messaged him and said this is not set till 11.
he? All right. So we're holding those. Let's do Andrew Stevens, SEAC. 25T7174451.
Good morning, Your Honor. We're all the way on behalf of the people.
Mayor, police and sound report, John Collector, latest P5, representing Mr. Andrew Stephen SEAC.
Mr. SEAC, your name, sir?
Andrew Stevens here.
You're going to behave today, right?
Yes, sir.
You're not going to act like you did last time, right?
No, sir.
Okay, because if you do, we're going to have a problem, okay?
Yes, sir.
Good. All right. You can have a seat, sir. This is the time and date scheduled for a preliminary exam. I have a one count assault with intent to do great bodily harm less than murder or by strangulation. The other two are 93 and 1 year misdemeanors. So there's no right to an exam on those. Any preliminary matters on this, Ms. Allen?
This is a co-defendant case. Well, Andrew SEAC has somebody gave me down. It's listed on the.
Right.
I want to make sure, I believe she has been KPS'd in the past. I know that there's that warrant out, she hasn't been here.
Lisa, can you check on that?
What's the co-defendant's name?
It's Breanna, BREANNA. Love, LUV. Last name is Pett, PETT.
It's in warrant status. She's never appeared.
I want to make sure that everything was fine on that.
Okay.
And also the assault and battery charge is for her, to see on the information. So, the felony charge is not. If I wrote the information for her.
Well, that's correct, but she also was charged with assault or assault and battery as it relates to count 2.
Yeah.
So
that's
the only count pending against her. Okay. Anything else that you want to bring up before we start?
Well, sequestration, but I don't believe anybody in this court was a witness to the incident.
All right. Any of the individuals out here are going to be witnesses today for you, Ms. Tucker Davis, or at the time of trial?
No, Your Honor.
Okay, all witnesses, with the exception of the officer in charge and the defendant are to leave the courtroom.
And
Any preliminary matters from you, Ms. Tucker Davis?
No, Your
Call your first witness.
Your Honor, I want to make it clear to the court, I will be moving forward on MCL 768.27C based on the statements to the officer. We do have to complain it here today, but I will have the officer testify to it.
Okay. Everyone come on.
And we would make our standing objection to that for the right of confrontation. Confrontation with the complainant, right?
Thank you.
Would you like me to respond, Your Honor?
Yeah, go ahead. I mean, I think we take it up one at a time, frankly, as he starts to testify. You can lodge your objections. If you're basing it on hearsay, I don't know if it's going to fall within a rule, an exception or not, but otherwise, let's just play it like that. You can feel free to stand up and object on any of his statements, okay?
The statute, evidence of a statement by declaring it's admissible under 1E, if that statement was made to a law enforcement officer.
Right.
And so at the time that people call Officer Garrett Hughes,
Okay?
I not.
We're all set on the piece, dominating, leading the sheet.
Okay, officer, come on up here.
Unless the Your Honor, I don't think the chair and apologize. The officer charged fatally. They take that Officer Treviniak. He's here filling in.
Okay.
Officer charged.
Sir, raise your right hand. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God.
Yeah.
All right, have a seat, please. Can you state your name and spell your name for my recorder, please?
My name is Garrett Hughes, Garrett, last name Hughes.
Thank you, officer. You can proceed.
Thank you, Your Honor. Mr. Hughes. Where do you work?
Trent Police Department,
And what do you do there?
patrol officer.
What are your roles and responsibilities within that role?
Well, him, sorry.
I'm sorry. What are your duties and responsibilities within that role?
Patrolling the streets and just doing traffic stuff, responding to calls when citizens call.
How long have you been working there?
Just over 2 years.
So I'm gonna take you back to June 22nd, 2025. Were you working that day?
Yes, ma'am.
Do you recall where you on dispatch?
I was on patrol.
And were you dispatched, excuse me, to 39114 4th Street in the city of Trenton?
Yes, I was.
And was it apartment 221?
Yes,
And that's in Wayne County?
correct.
Do you recall what the reason you were dispatched to that location was?
Yes, it called him out at an assault that just took place where the suspect just fled before I was getting called.
And when you got there, did anybody identify themselves to you?
Who entered the door? Yes, it was Miss Shelley Xavier. She entered the door, being very emotional, with a bloody nose and a very dark left eye.
Were those your observations of her that day?
Correct, yes.
Do you recall what time it was?
I believe it was just before 1 o'clock in the morning.
And did she say anything to you?
Objection.
I mean, what was your emotional state at the time? You said she had a bloody nose. She had a dark black eye.
Yes, sir.
What else was her physical demeanor like?
She was crying, she was upset.
It's clearly an excited utterance. You don't even need to get to that statute, so I'm gonna overrule. Go ahead.
And I apologize. What did she say to you?
He said he did it and he had gone.
And did she tell you what she meant by that?
Well, with my previous experience dealing with that appointment and the calls, I knew who she was talking about. It was Mr. Andrew Siak.
And did she at all that night tell you his name?
After I got in and started talking to her, yes.
And did she identify, regarding that sentence that she had said to you about he did it and he's gone, did she tell you that she met Andrew Siak?
Yes,
And do you see him in the courtroom today?
I did.
Did you please come up there? And tell me what color he's wearing.
Gray, white.
Let the record reflect that witness has identified the defendant.
The record should so reflect.
And, so what did she tell you that night?
She told me that Mr. Siak and there's an argument over a dog involving Mr. Siak and his daughter. Mr. Siak and his daughter went to a pride event and left the dog at the apartment. And Miss Zajac had no recollection of an agreement of leaving the dog there.
And let me stop you there. What did you say? A parade? What? Pride event?
Pride event.
Oh, pride event. Okay. And, so you said there was an agreement about the dog. Was she at the apartment?
Who, the daughter?
No, Shelley Sage.
Shelley was there, yes.
And, what else did she say after that?
So Shelley was upset that the dog was there. She did not agree to watch the dog. She told me she tried to contact Mr. Siak. He was not answering his phone. So she contacted his daughter and explained to her that she did not agree to watch a dog, did not want to watch a dog.
Anything happened next?
The daughter began to yell and scream at her and told her that she'd be right back over to pick the dog up.
And what happened after that? What did Shelley Sage tell you happened after that?
She told me that Mr. Siak and his daughter arrived. His daughter came into the apartment and started whipping her. That's what Shelley told me.
And was that regarding Brianna Pett?
Correct.
And
Did you say whipping?
Whipping. That's what Shelley told me is whipping.
Could you repeat that? That she began, what was it?
Whipping.
Whipping her?
Yes.
And by that you mean Brianna began, in those words, whipping Shelley Zajac?
Correct.
And then what happened? Or what did she say happened next?
Shelley told me that she removed herself from the doorway into the living room area of the apartment near the TV. And Mrs. Pat began to punch her. And that is when Shelley told me that Andrew was cheering her on.
And
As in cheering on his daughter of beating up Ms. Zajac.
did Andrew then do anything else?
Yes, that is when Andrew began on assaulting Ms. Zajac.
And how did she say he did that?
She told me he was punching her in the head, and then at one point got on top of her, mounted her, and put his hands around her neck, and he started choking her.
And did you ask, or did she tell you at all if she could read when he was choking her?
She told me she did not lose consciousness, but
Said what?
that she did not lose consciousness.
Did she describe that he put his hands around her neck?
Correct. And then I did observe when I first arrived at the apartment, red marks around her neck.
And what did she say happened next?
She told me that they left. They took both sets of her car keys to both her vehicles and her cell phone, so she could not contact the police regarding the matter.
And did she say to you, if Andrew see I did anything off that? If you recall.
No, not that I recall.
Did she tell you who Andrew Siak was to her?
At that point, their boyfriend, girlfriend, dating on and off for approximately two months.
And did she say that to you that night?
Yes,
Did you take any photos that night?
I took multiple photographs of Ms. Dajac's complete body, that she was bruised and battered up and burned across the majority of her body.
Burned.
Yes, sir.
And so you said burned. Did she happen to tell you why she was burned?
Yes, she did. I was asking her about her black eye.
I like McNally coming in with whipped, burned. What the hell's going on here?
And she stated that the black eye was not from the night of the 22nd. It was from a previous incident. Ms. Zajac told me, due to the numerous police calls we've gotten to the apartment, they were all real police calls. They were all calls of help. But
I would object here. This is not cited utterance. This is pure hearsay.
Any response?
Your Honor, just again, under MCL 768.27C, these statements are admissible so long as they happen to a law enforcement officer, and they are regarding a domestic violence incident. These are the statements that she said to him that night.
I mean, the statements have to be corroborated. Is your, I'm gonna admit it conditionally on you're bringing in Ms. Zajic, correct?
No,
You're not bringing in Ms. Zajic?
I cannot.
She didn't show up?
She is scared. She is intoxicated.
And I expand my objection because this is the second time to say that and here she's not present. Objection to this officer testifying. She was present 2 times and out unruly in the courthouse and had to be removed.
Your Honor, the statute does not, it is not how, the statute allows his statements, regardless of whether or not she is present.
Hang on a second. Was she subpoenaed here?
Correct, Your Honor.
She was subpoenaed.
Hang on a second. Whipped, burnt, and now drunk? What the hell is this?
And she showed up drunk?
But her availability does not weigh on whether or not this statute can be
Oh, I know, but it has to be corroborated, right?
corroborated, yes, and that corroborated by evidence other than statements that are admissible under only the section.
You're going into detail about prior incidents now.
Yes.
And
I understand what the statute says. I understand what the statute says. I want you to bring in this lady. Bring in Ms. Zajic right now.
you have to wait to still go. Would you like me to excuse him for the time being, or?
No, bring her in.
Bring in Drunky.
He's not going to say anything.
Bring in Drunky. Let's take a look. Let's do a field sobriety test right here in court.
You are here in the small claims division of 3B District Court. The rules are relaxed, they are not as strict as they are in the general division of the court.
Yeah, put her right in there. Ma'am, can you tell me your name? Can you tell me your name, ma'am? You're in a courtroom now, you know that?
Yes, yes, I do.
Tell me your name.
My name is Shelley.
Shelley what?
That's Zajic. Shelley Zajic.
Prosecutor tells me they subpoenaed you here today.
I don't receive mail, my mailbox.
Did somebody personally serve her with a subpoena?
We attempted to serve her personally. She didn't get it, but we were in contact with her. She was verbally served by Sergeant Driscoll. And we had to go get her today.
She was picked up by officers this morning.
Oh boy, oh boy, oh boy. How can you serve something? There's only one way to serve a subpoena.
Exactly.
Ma'am, I didn't ask you for your input. I'm trying to figure out whether or not I should lock you up, because if you were subpoenaed and
He's pissed at everybody. You don't know how to subpoena. You're drunk. Shut up. I'm trying to conduct a hearing. Everybody act normal.
you show up on this state where it's impossible for you to testify, as far as I'm concerned, I'm I'm going to find that you've ignored a court order to appear. You couldn't even walk when you got him. So don't start playing lawyer with me. Oh, boy. You're in a bad way. You did not drive here, right?
No, Your Honor, she was police brought here by.
Right. But if they didn't properly subpoena, what are they doing picking her up and bringing her back? I mean, John, I'm just telling you, this stuff is going on now today. I just can't imagine. She is a mess.
I am a mess.
Ma'am, I don't need you to confirm that. I just observed it from my own eyes. Don't argue with me.
I mean, she wasn't. She was agreeing with you, to be honest.
They have to properly serve.
Your Honor, I can't tell you whether or not she was personally served.
He just all but told me that you verbally, Driscoll gave her the order or that's not proper service. I know you do. I'm not saying you didn't. They might have gone out there 89 times. She might have stayed in the house 89 times. I don't know. But you still have to have proper subpoenas. And you can't be picking people up without them being properly served. And if she's served with a subpoena and she shows up like this again,
Okay, I don't know why he's got a bee in his bonnet about this. That's true if you're trying to enforce a subpoena. But if you just call somebody and they come and testify voluntarily, that's fine too. I think the only thing I can think of is he's cranky because if the subpoena is properly serviced, he can now bang her for not. Now he's got jurisdiction to do stuff to her because she had a subpoena and she's not available for it. But he really can't because there isn't proper service of the subpoena.
I'll lock her up for a week. And I'm going to make sure that she stays in jail where she can't drink, can't drug, can't start rendering opinions to judges. Why is this funny, Ms. Zajic? I'm not the least bit amused.
Oh, I am. I mean, go Judge. I'm with you. I'm with you, my man. But it's hilarious from my vantage point.
Now, here's what I'm doing. I'm stopping this proceeding right now. I'm adjourning this 1 week. You can't just have officers come up here and reiterate things that happen. I mean, I know that this statute exists, and honestly,
It was a decision that we had to make given the circumstances.
I'm adjourning 1 week. She needs to be properly served.
Understood, Your Honor.
Adjourn 1 week. Mr. Siak, there were allegations.
She needs to be properly served so when she shows up drunk again, I can throw her in jail. That's really it.
That you had contact with her. Remember those? Yes, I do. If I find out you have any contact with her, you will be sitting in jail as long as it takes for the cows to come home. We with one another? Yes, sir. Lisa, I don't know how I'm going to get through all these cases in December 2nd. At what time? Ma'am, if you're subpoenaed and you show up like this again, I'm telling you, you are going to have you're not going to like what I'm going to do. We're adjourning the preliminary exam. I don't even know when I can do it next week. You give me a time, Lisa?
December 2nd at 11.
At 11. Okay, good enough. That's what we're doing. December 2nd at 11. Thank you. You can step down. You're going to have to be here too. Thank you.
All right, there you have it. There you have it. Everybody come back on December 2nd. There's a high probability you all end up in jail. Have a good Thanksgiving.
Follow the rules of evidence or procedure. Neither Neither party is allowed to have an attorney in small claims court. Raise your right hand. You all swear or affirm that any testimony you are about to give in this matter will be true, to the best of your knowledge and belief. There is no formal record in small claims court, and there is no appeal. Any decision made here is final. Either party has the right to remove the matter from the small claims division to the regular division of the court, where you could sue for up to $25,000. But you would have to tell me before we begin. Once we begin here, any decision made here is final.